Yes.
May I please, your lordship? Lordship, I'm seeking an adjournment for item 37, lordship.
Wait, let him begin the proceeding.
Lordship.
Adjournment request from item number 1 to 23.
Yes.
Please, your lordship, I beg to mention item number 22.
22.
This matter-
22.
Yes,
General slip circulate. All right. One. Take the date.
What?
Take the date.
Second March. 2-3.
Yes.
From item number 24 to 29. From item number 30 to 42.
May I please, your lordship? Lordship, with regard to item 37, I'm seeking an adjournment, lordship. Lordship,
On behalf of
DK Sharma, lordship. DK Sharma. I'm the petitioner, lordship, on behalf of DK Sharma.
I have a prayer, Lordship. After vacation, Lord.
Naturally,
After vacation.
as prayed for on behalf of the petitioner and agreed to by the council for the respondent, re-notify this case on give a date on February.
11 February.
Much obliged, lordship.
Wait, please, Your Lordship.
Yes.
Lordship, item number 34, my lord. I appear-
34.
34, my lord. I appear for the appellant, my lord. I've taken consent from the other side also. We're seeking for a short date, my lord. Subject to Your Lordship's convenience.
See, the most convenient thing is that you argue the case.
My
If
lord,
you don't argue the case, then accept the date of our calendar.
my lord.
Yes. As, can we say jointly prayed for? No.
It is my prayer, my lord.
It's their prayer, your lordship.
Item number 35 and 36.
34,
34, your lordship.
34, my lord.
Okay.
Will be the
As prayed for on behalf of the appellant.
appellant, my lord.
Oh, this is the freezing of the
Yes,
Yes,
account.
your
Yes, my
lordship.
lord. Yes, my lord.
What do you have to do in this?
No, my lord, the issue here pertains to whether the SBI being a government instrumentality, my lord, should it have bound itself by a mandate form or by a single letter which was preferred by one of the partners?
I don't think so. The partnership firm has been wound up
My lord,
from the date when that notice was given.
my lord.
Now, thereafter, the rules say that, it can't be opened at your instance.
No, what has happened, my lord?
And you have filed a title suit, haven't you?
We have, my lord, that is for, my lord,
Therefore, you could go before the trial court for
No.
the relief.
my lord, we are there for a separate reason. The cause of action, then,
Whatever it is, while the matter is pending before the trial court, you can always go. Anyway, you want time, we'll give you March.
my lord, February, my lord, a shorter date, my lord, a shorter date, my lord, if permissible, my
Argue today?
my lord,
Argue today?
on the later part of February, my lord, if that is convenient for,
Later part of February. As prayed for on behalf of the appellant and agreed to by the council for the respondent, let this matter come up for consideration on so and so date.
my lord, I'm grateful.
25 2.
Obliged, your lordship.
25 2. Okay.
25.
may I please, lordship? Lordship, I beg to mention item number 42.
Adjournment slip circulated, all right.
6 March. 6 March. Any other request?
May I please, your lordship. I beg to mention for listing a writ appeal, Lordship. Wednesday or Friday, Lordship.
No, but what is the matter? What is the
Lordship,
urgency?
Present appellant challenged a corrigendum which is issued by Director of Secondary Education. Your Honor, your lordship, however, the single judge failed to appreciate the same, Lordship.
No, this is very vague. You tell us if you're mentioning in the last week, for a case to be listed, you must tell us what is the urgency.
Lordship, urgency is here.
If you have not read the file, you can mention tomorrow.
Applicant are graduate.
Mention tomorrow after reading the file, after formulating your ground for uplisting the matter.
Alright.
Yes.
Daily list for orders, item 1 to 19.
We will not hear this
Yes,
matter in this composition. Let all these cases go out of our list and be placed before a bench of which one of us, Arun Dev Chaudhary J, is not a part. Let these cases be let these cases be placed before the Chief Justice in the administrative side for allocating an appropriate bench.
Item 20,
30 days delay, yeah.
May I please? As per office note dated 4/12/25, my lord.
Respondent number 3 is not available.
My lord. As per office note dated 4/12/25, my lord.
No such person in this address.
My
Give
lord,
a correct address of respondent number 3. We will condone the delay, but the other side should be here.
my lord.
Yeah, except respondent number 3, all other respondents have been served. The office note indicates that respondent number 3 could not be traced because no person by his name and address is available on the address given by the appellant, by the applicant appellant. Stop. Let fresh notice be issued to respondent number 3 on steps being taken by the appellant / applicant, including furnishing of correct and present address of respondent number 3, both modes returnable, February.
Published.
27 February. Item 21,
Yeah.
May we-
Service not complete. Yes, service not complete. Service is complete.
Yes, sir, finally to be heard.
Let this matter be listed for under the, today you want to argue?
Yes.
Not under
Well, it's
the,
enough opportunities. They've got more than 4 opportunities, my lords, and as well as condoned delay in August, my lords, and said that it will be heard on the next date. But 4 opportunities have been taken by the petitioner.
why has it come for orders?
Well, in fact,
Well, it's ready for.
there is my lord, direction to make an endeavor if amicably things can be done.
Yes,
So,
did
but-
we record it?
Yes.
Yes, it has been recorded.
Yes, my lord.
And that I've been, my lord, informed, my lord, by instruction that that is not possible, my lord.
So therefore argue the,
That's gone, my lord. That is,
argue.
lord. Now, basically, my lord, my contention would be, my lord, by filing this appeal.
Hmm.
By filing this appeal, my lord, I have been pushed up to
No,
a
no,
worse
this
of
is-
condition, my lord.
This is just a minute. Let us see the order which is sought to be revised.
My lord, it's at page 20, my lord.
All right, just
Public-
give me 1 minute.
Lordship.
Tell me one thing, why do we go for, why are you asking for review on what ground?
But firstly, my lord, by filing this appeal, my lord, I have been pushed to a my lord, wash of condition, my lord. Now,
What
this
condition? You're the NHIC, no?
NHIDCL, my lord.
So what condition? You
Now, my lord, will find, my lord, a paragraph
can't
8.
enforce that against the subcontractor whom you had permitted.
My lord. My lord, the.
Where is the fault line in this judgment requiring review?
Mr.
Mr. Saikia, just limit your argument to the fault line in the judgment, which entitles you to come before this court for a review of the judgment.
My lord, firstly, my lord, in paragraph 18, my lord, the Honorable Division Bench has found there is no subsisting contract between, my lord, NHIDCL and the subcontractor. If any claim the subcontractor has, it is against the principal contractor. And therefore, my lord, the judgment of the learned Honorable Single Judge has been
Absolutely
set.
wrong proposition, Mr. Saikia. Absolutely wrong proposition. See, the amount due against the contractor, principal contractor who has run away to Spain. Now you can sue him, whatever, but do you have any objection to the work concluded by the subcontractor? That's him.
My lord,
I will
So,
not
that is-
raise
this is an
I will
advocate,
not
my lord.
raise my voice, neither will I repeat because I have a sore throat. So
Right.
when I say something, just respond to that.
Exactly, my lord. My lord, we have admitted that he has executed the work to the extent of 11 crores and odd. Thing is that, my lord, that principal contractor, he did not perform his work, so therefore we are entitled to some amount from him. So
You
those,
sue him.
these amount which, my lord, the subcontractor.
You
is at-
allowed it. Just a second.
Right.
If you take that plea that it is whatever claim he has, he can claim it from his main contractor who had subleased the work to him. That's a wrong proposition. A state cannot resort to this logic. You have done the work, and then what is there? With their permission, work could not have been subleased with their permission.
And secondly, your lordship will see, my lord, having said so, my lord, the honorable court has, my lord, said, my lord, he is a supplier, I am a buyer. And there exists, my lord, a relationship. So therefore, the liberty was given to them.
Therefore, we said, now tell us something which will make us, consider this review application.
Madam, my
Two
prayer
courts
would
have
be,
allowed his claim.
my prayer would be, my lord, review to the extent of, my lord, finding of the court that there is a relationship of
Filing
buyer
of
and
the-
seller.
Filing of the
Finding of the honorable division bench, my lord, that there is existence of a, my lord, buyer and seller relationship between buyer and, my lord, supplier relationship between, my lord, subcontractor and the NHIDCL. To that extent, my lord, this requires, my lord, examination of the facts as well as the law.
No.
And
Which paragraph? Tell us.
my lord, will find at page 30, my lord. And this is never a pleaded case of the, my lord, writ petitioner. Page 30, my lord. Page 31, my lord. Paragraph 30. My lord, this
Just
power.
1 second.
Lord.
We don't follow this. In the present, just read that paragraph.
In the present case,
That's a surplusage so far as the rights of the subcontractor is concerned. I mean, I don't think this was to be incorporated in the appellate order.
But
But
in the
why do
present
we
case, as
disturb
has
it?
noted here in above, the fact that subcontractor is a micro, small and medium enterprise and has supplied goods and or rendered services which are available by the appellant number 1 as a buyer within the meaning of the Act of 2006 is not in dispute, or nor there is any controversy regarding the fact that the value of the work executed by the subcontractor with which amount has been specifically admitted by the appellant by filing the affidavit. In view of the above,
Why do we? But why do we remove this? Why do we truncate this judgment
Well,
of?
Well,
that
first of
paragraph?
all, my lord, the works contract, my lord, doesn't come within the purview of the.
This is, Mr. Saikia, this is a surplusage. The issue could have been decided that you permitted the main contractor to sublease the work to the subcontractor. He has executed the work to which you have no objection. You must pay him.
But that is, but if this my lord, paragraph goes in that case, my lord, that will be, but by my lord incorporating, if this remains, my lord, it will have a my lord far-reaching consequences, my lord. Because all the subcontractor, my lord, if they, my lord, if the principal contractor default, then the subcontractor will come into the play, my lord. And therefore, in the, my lord, the agreements, always we incorporate a clause 4, so that, my lord, the young contractors can be given an opportunity to subcontract the, to have their experience in the field, my lord. Now that again, my lord, it has to be recasted perhaps, my lord, in the ministry level, because this is the clause. It's for the, my lord, benefit of the local, my lord, the contractors who otherwise cannot have, my lord.
As I told you, that paragraph is a surplusage.
Lordship, my lord. No,
Doesn't matter.
now thing is that pursuant to this, my lord, they have filed an application before the MSME. And my lord, MSME, my lord, will have nothing to, my lord, adjudicate, because this court has already held that I am the buyer, he is the supplier, only the competition would be required. Only the competition of the amount, that's principal amount is already agreed, and then, my lord, the interest part under section, my lord, 15 and 16, my lord. So that is only, and that what, my lord, I say, my lord, by filing the appeal, I have been, my lord, pushed to the, my lord, workshop conditions, my lord.
I don't understand that.
Lordship, my lord.
No, initially the petition was allowed. Therefore, they filed an appeal.
That what is the, my lord, Latin phrase, my lord, reformatio in pairs, my lord.
This part.
It's also.
No. We are not inclined to do anything. We will not emasculate of this judgment of any paragraph. We can say, we can say that, yes, what is your view?
Please, my lords. My lords, with due
Be
respect, my
happy,
lords.
be happy with the payment.
My lords, as a matter of fact, my lords, that's what we said in September before a coordinate bench. I have been held to have done the work, and what's good for
Oh,
the.
don't repeat, Mr.
No, my lords, what I'm saying is there were other subcontractors to which they happily paid. So I am saying what's good for the goose is good for the kind. They've already paid the other subcontractors. I pointed out those things, my lords, because kindly have page 405 of the writ appeal.
We are not getting into those facts. He has not been able to demonstrate any fault line.
Because I am happy with the dismissal of the review petition. That is all I want to then submit, my lords.
That's right, but then.
They appeared before the MSME. They've already appeared before the MSME last year, my lords. And then they got wiser and they thought that they will come and take a second shot at the cherry.
MSME, why have you gone to MSME? For what?
But I have gone to the MSME because this court in the impugned judgment says that I can go to the MSME. This court says that the order of the single judge was upset to the extent that where they have been directed to pay the entire amount to me. Because the learned division, the coordinate bench said that you go to the MSME and you raise your claim over there.
You should have told the division bench, no need for this.
I am
Otherwise, if
absolutely
you have-
happy in September, on 15 September
Just a
25.
minute. If you have an avenue before MSME, go before there.
I'm there now.
So why should we pass an order?
Please, well, that's why I'm saying the review petition may be dismissed, my lords. I'm already, the MSME proceedings are not going on because
No,
of this
with respect
tendency.
to payment, you just don't shift the.
Because they're not paying me anything.
Would you be satisfied with the payment?
I have always said that
You not press that petition before MSME.
not at all. My lords will kindly have my submission on 15th of September before this
Take it
court.
We have heard Mr. P.J. Saikia, learned senior advocate for the petitioner, and Mr. S.P. Roy
No, man, it's Mohit Paul.
and Mr. Mohit Paul, learned advocate for the respond number,
Respondent number 1 and 2, my lords.
response number 1 and 2. By the impugned judgment sought to be revised against, the directions issued by the learned single judge for making payment towards the work executed by response number 1 and 2 has been affirmed by the division bench of this court. Mr. Saikia has not been able to show any
My
ground.
lord, judgment has been set aside. Single judge's judgment has been set
Has
aside.
been set aside. But
Lordship.
why this appeal was?
Lordship. Paragraph 20, my lord.
But that's what Mr. Seki has at pains. It's a double-edged sword. Earlier, they had to return the money with simple interest to me. Now it will be with compounded interest.
Did single judge do?
Single judge has my lord, taken my lord, recourse to provision of section 70. Said that since you have admitted that he has executed the work, amount of 11 crores is pending, so it fulfills the section 70, so you pay.
Yes. Thereafter,
Thereafter, we have appealed against.
and what happened in appeal? They affirmed
Appeal,
it.
my
no?
lord, appeal, my lord, the Honorable Division Bench has set aside the judgment. But then, my lord, having held in paragraph 30, that there exists a buyer and seller relation, buyer and supplier relationship under the my lord, MSME Act. So they were given the liberty to approach the MSME
No, no,
council.
challenging it now here.
My lord,
If you, I mean, then we don't do anything. No, that has been set aside. What do we do? Now we can revise this by saying that considering the fact that you have agreed to pay principal.
But the
they will
single
pay
judge's view, if I may just point out, was the para 40. Therefore, the instant writ petition stands allowed by directing release of the payments to the petitioners for the work done immediately. As in the meantime, almost 8 years have passed. It is
that
further.
Oh, I thought it otherwise. I read paragraph 30 and I said that it has been affirmed this is a surplusage. This is something else. Now, therefore, if you're ready and they're also ready, we will conclude this. We'll say
Yes,
that
with the simple banking rates, my lords. I'm okay with the interest at the banking rates, my lords.
yes, what do you have to say? Oh, no, I missed out on this.
Because I want money, my lords. If I go to MSME, I know it will be further delayed. They'll
Then
come in appeal.
why are you delaying it? There was some talk of some
Since
negotiations.
September, I've been asking them.
for that, my lord, I'll have to obtain instruction.
Well,
No,
they've
no, no,
taken
no,
sufficient
again-
time with
again-
regard to that.
Again, it is getting delayed.
No, but otherwise, my lord, it will be difficult on my part to, my
The
lord,
difficulty, Mr. Paul, is this. Now, if we don't grant it, it has to be by consent. Otherwise, we'll say that there is nothing wrong in it. You go there, the matter is there.
My lord's direction
That's-
can always be there without
Just a
being
minute.
consent. I am consenting to it.
Just a minute. We will not find any fault with this order otherwise. We can find fault with this order and say that there was no necessity of relegating the parties to MSME when it is admitted that work has been executed and we are ready to pay. You have to accept it. That you have to accept. If you accept it, then you will have also to sit across the table and decide whether you will charge interest on delayed payment.
I will charge simple interest is all I'm saying, my lords.
Forgo interest
lords-
and he forgoes everything.
I'm sorry, my lords.
Forgo your interest.
Because that is substantial amount, my lords, today.
Then
My
he'll
lords,
have-
I am only asking, I am not even in MSME, they have to pay 3 times the interest. It will be compounded. I am saying I'm forgoing it.
Then you get the money.
Then my lords may send it to MSME only. Then if they are not coming on, my lords, they will also need to give consent.
We will dismiss this review. You're already there.
I'll do that then, my lords. My lords, I can't be giving.
We are interested in getting you paid.
I am also interested,
The
my lords,
difficulty
but with some interest, my lords.
that he will have to take instruction, then it continues.
Because I don't want it to continue further. There have been sufficient time which has been lost.
If you petition, you succeed.
My lords may do that, my lords.
Take it. We have heard Sri PJ Saikial and senior advocate for the appellant and Mr. Paul. Mr.
Mohit Paul, my lords.
Moise Paul.
Basically, my lord, agreed.
Respondents number
finding
now,
of the
now
court.
finished.
Lordship.
We said that you take the call just now. If you're ready to pay simple interest, he is not going to
That, my
press
lord,
for
I have to
anything.
take, my lord, obtain instruction. My lord, I have to-
But that was the offer in September as well, my lords, with due respect, my lords.
Take
They've taken
instructions
3 opportunities for that.
Take instructions by tomorrow, otherwise we dismiss your review petition, go and fight before MSME, and then you will have to pay 5 times more, 3 times more.
And with the meter running with in years, it will be actually 5 times, my lords were correct. Because with the passage of time, it's been 8 years since I did this work.
Take your call, ask the person on, we will put it on
Let me
Friday.
say something day after tomorrow, my lord, I'll
Yeah.
just,
Because we can have it tomorrow, my lords. My lords, I am in
No,
difficulty for
we
day
will
after.
dictate something and then take them.
Can your lordships have it tomorrow, my lords?
Just a minute. We have heard Mr. PJ Saikial and senior advocate for the petitioner and Mr. Mohit Paul for response number 1 and 2. The response, the response number 1 and 2 are the subcontractors under the principal contractor, namely Messrs. Corson Corvium Construction SA, bracket hereinafter referred to as CCCSA, comma, a company of Spain. The principal contractor had been entrusted with the work, had been entrusted into an engineering procurement and construction agreement, had entered into it. The principal contractor had, the appellant, the petitioner had entered into an agreement with the principal contractor regarding engineering procurement and construction. For the execution of the work of construction of four laning of Jorhat Jhanji section of NH 37 in the state of Assam, for a stretch of road, for a stretch of land. A tripartite agreement had been entered into between the MORTH, CCCSA, and the NHIDCL so as to facilitate the work. The appellant permitted the principal contractor to enter into a subcontract with other entities for completion of the project work. The response number 1 and 2 are the subcontractors, as noted above, who completed the work valued at rupees 11,06,85,770 and had raised the bills. The appellant was reluctant to make payment for the reason that against the principal contractor, there was a huge amount due by way of damages and compensation for the company having left the work midway, which amount includes the amount of the work, amount for the work completed by response number 1 and 2. When the payments were not forthcoming, the response number 1 and 2 preferred a writ petition before this court by
What's writ petition?
WPC number so and so. Yeah, by WPC number
Please, well, it's 7326 of 2018
so and so, which was allowed,
on
And-
11th of
which was allowed, and the appellant and the petitioner was directed to make payments to the subcontractor in view of admission of the fact that the work was executed by response number 1 and 2 to the satisfaction of the appellant. This order passed by the learned single judge in WPC number so and so was challenged by the appellant in appeal. Was challenged by the appellant in appeal in WA number so and so, which was disposed of on 19/8/2024, whereby the judgment of the learned single judge was set aside and judgment was set aside, and the respondent number 1 and 2 were permitted to pursue their remedies for payment before the Department of MSME for the reason that the respondents number 1 and 2 acted in discharge of their contractual obligation towards CCCSA and not the appellants. The division bench was of the view that the question of fastening any liability on the appellant for the work done by the subcontractor by taking recourse to Section 70 of the Indian Contract Act ought not to have arisen in that appeal The division bench, however, rejecting such argument, held that the conditions precedent for invoking section 70 of the Contract Act had not been fulfilled by the subcontractors so as to maintain the writ petition against the appellants. Thus, the appeal of the applicant was allowed. Despite this, the present application has been filed for the reason that before the Department of MSME, the obligation of the petitioner / appellant would be to pay the amount of bill raised by the subcontractors / respondent number 1 and 2, along with all interest. Realizing this, the petitioner / appellant now considers it to be more beneficial to agree to make payment of the amount provided respondents number 1 and 2 agree to such a proposal. Mr. Paul fairly conceded that respondents number 1 and 2 shall not have any objection if the amount in question is paid along with simple interest from the date when it was payable.
There's an RBI banking rate interest, so that may be there. It keeps fluctuating, so.
Bank interest. Mr. Saikia seeks some more time.
No, it is not my proposal, my lord, that the NHIDCL is agreed to pay, my lord.
Then why do you make the court write so much? We will dismiss your revision, nothing.
Lordship. That, but I
Don't
have-
press this
I have-
revision.
I have
Then
not
don't
agreed.
press this review
Well,
then.
my grievance only to the finding of the division
No,
bench
maybe
that
they
they are
get-
they are subsisting the
All this
supply and
useless niche mein ek paragraph likho. No good ground has been made out by the learned counsel by the learned senior advocate for the petitioner for us to interfere with the impugned judgment. The review is dismissed.
Oblige, my lords.
We were giving you an opportunity. You could have called your client would have been a beneficiary in this.
no, my lord, this
You got frightened because we.
It's a
that-
David versus Goliath
No,
battle, my lords.
my lord, that is
you are also.
No, my lords, I have because of this one contract, I have been rendered NPA now.
It is a fight between Goliath 1 and Goliath 2,
No, not at all, my lords.
not David and Goliath.
my lord, I cannot take it the responsibility of my lord making the proposal because there's some
Then-
negotiation were there between
Dismiss
them.
it. You have your negotiations apart from this court.
Yes,
Don't bother us.
What
Please,
my
my
prayer
lords.
was, if your lordship would have fixed it for tomorrow or day after, my lord, I would have obtained verbally instruction and then, my lord, I would have submitted.
No,
That is-
then again tomorrow or something. We find no merit in this.
Oblige, my lords.
Obliged.
उसको नहीं ऊपर से फैक्ट्स लिखा तो यस
Deeply obliged, my lord.
Item 23.
दूसरे तरीके से लिखा दूंगा आइटम 678 सर्विस रिपोर्ट of export number 34589 what is your mandate क्या है delay for how many 74 days who appears for the respondents MS Sharma
125.
125 who are the others private party
No, but the
except notice on behalf of them
on this, I think Arban was the guest who is pending counsel. I think Mr. Nayak is expected.
inform Mr. Nayak he'll be here we will condone the delay I'm asking you
My lord, obliged.
or we say that awaiting the service of notice on so and so or you call we ask him to
I'll
accept
call,
the notice.
my
Pending counsel is there.
We are keeping it for tomorrow. Ask him to be here. Mr. Sharma will be here. Mr. Nayak, tell him we will condone the delay.
obliged.
Tomorrow.
My
lord, in this case, notice has to go away. Implement petition is for the first time, Lord. This is filed.
Like IA number so and so.
9.9.
IA number so and so. By this implement application, a prayer has been made for impleting so and so. Current details is not as party respondents in the present appeal. let notice be issued to so-and-so on steps being taken by the applicant within a period of 1 week. Both modes returnable on so-and-so.
Reviewless.
27 February.
The-
Item 25,
ठीक है चला गया 4 and 5
My lordship, my lord, the service on.
Awaiting the report of service. To response number 4 and 5, the matter is adjourned to January.
6 February. Item 26 to 28.
Mr. Katniar, you have filed an affidavit, but where is that response to the poser? That without notifying the amendment in 2024 or 25, you have issued the advertisement. What do you have to say to that?
Yes, my lord. In fact, it has not been notified till date, my lord.
Uh,
I'm supposed to place the instruction today, my lord. In fact,
What is
today
the
they have,
instruction?
this is the rule, my lord. Today they have sent for publication, but it was given effect from 28th of October.
And that they can always do.
On that day, my lord, cabinet approved this amendment, my lord.
Come forward, eh?
Maybe. This is, as on today, it is not published, my lord. So this has not come into force.
But list the IN number so-and-so, along with the writ petition number so-and-so. On, argue on in the first week of January.
Yes.
First week of January.
My lord, till then status quo as on today be
Doesn't
maintained, my lord.
matter. Let it continue.
Obliged, my
My
lord.
lord, one thing, my lord, this
We have
recruitment.
given you an early date. They are not going to do anything now.
Obliged.
Right? But
8 January. Item 29,
I is for condemnation of delay of 40 days, your lordship. Notice.
coming for the first time.
First time it has come.
You are appearing for whom?
Lordship, I am referring for respondent 1, 2, 3, 4, 5. Cooperation Department.
7, 8 and
They are private respondents.
8 and 9, your lordship.
7, 8 and
7, 8 and
There's an application seeking condemnation of delay of so many days in preparing the appeal. So-and-so appears for response number
1, 2, 3, 4, 5.
3, 1 to
1 to 5.
1 to 5. 1 to 6. Let notices go. Let notices be issued to response number. ठीक है. Let notices be issued to response number 7 to 9. The steps being taken by the applicant within a period of 2 weeks, both more. returnable part.
6 March. Item 30,
Lordship, I have served the notice through the stay and the compliance affidavit has also been filed.
He is here.
yes,
He is here.
yes, Chief.
Lordship,
Are you?
Lordship, here the respondent number 2 initiated insolvency proceeding and we file an application challenging the maintainability of IBC proceeding. Lordship. That notice was issued and the time was granted to the respondent to file affidavit. But in the meantime, the matter was heard, but that application was not decided.
That's not the issue, Mr. Hyal.
Lordship.
Now, you had to, before appointing the resolution professional,
Lordship.
I think the maintainability, the jurisdiction,
Lordship.
that no CIRP has been instituted against the principal borrower, understandable.
Lordship.
It can be done. But then, if he questions the very determination of him being a personal guarantor, that has to be decided first before entering into anything. This is a special provision for personal guarantors,
Lordship.
correct?
Yes, Lord.
Now he says that there were loans in various tranches. The last of the sanctions loan, because there was a restructuring, he refused to give any personal guarantee. You acknowledge this,
Lordship.
and then how could you start a proceeding? You have started all right. That is your business. You invoke the jurisdiction of the court. But then the jurisdictional issue, the maintainability had to be decided first. Can you put the cart before the horse?
Lordship, I file an application, Lordship. On that application, Lordship, notice was issued and the bank took time.
That's all right.
No.
So the NCLT should have held back, no? Before asking him to supply info, before appointing a resolution professional who would otherwise immediately ask him to submit a plan. You have to say this. What is your response to this? I think I'm telling you the exact thing.
Lordship.
Yes.
Lordship, what I understand from the proceeding, Lordship, before deciding anything, Lordship, the NCLT is to decide my application, Lordship, since the notice was issued on that application. And Supreme Court is in PHR clarified that if the judicial point is there, then it is maintainable and court can decide this.
All right. Yes. What do you have to?
You see, your lordship, the law is settled. Their rights has not been taken away. Right now, only in 95 and preliminary observation has been made by the NCLT that let the
We are not agreeable. There was some confusion. I thought because he appears for the income tax department, therefore. No, Mr. Kell, no, sorry. The face of the council made me think that you are for the other thing.
Lordship,
The observations are meant for him.
your lordship RP has been appointed. And 95 to 99, there is no adjudicatory authority, your lordship. I have placed one judgment, your lordship. That is Jivrajka's judgment. The last page, your lordship. That is para 85, your lordship.
Para?
85. And the relevant one starts from 86 point, the conclusion part.
What does it say?
Yes, sir. The resolution professionals appointed under the section 97 serves a facilitative role.
Where are you reading?
That is para 86, your lordship.
We know someone.
And 86.3. Huh? 40. May I? After submissions of the report, they can go for their issues, your lordship. That is not that the right has been closed.
This is against what I am saying. Read the whole thing. Read the entire summary.
Yes, your lordship.
When it is a judgment of 2024.
Yes, your lord.
Oh, of 3 judges.
Yes.
What does it say?
Yes, your lordship. That no judicial adjudication is involved at the stage envisaged in section 95 to section 99. Then the resolution professional appointed under section 97 serves a facilitative role of collating all the facts relevant to the examination of application for the commencement of the insolvency resolution process, which has been preferred under section 94 or 95. The report to be submitted to the adjudicatory authority is recommendatory in nature on whether to accept or reject the application. The submissions that the hearing should be conducted by the adjudicatory authority for the purpose of determining the jurisdictional fact at the stage when it's appoint a resolution professional under section 97(5) IBC is rejected. No such adjudicatory function is contemplated at that stage. To read in such a requirement at that stage would be to rewrite the statute, which is impermissible in exercise of the judicial review. The resolution professional may exercise.
Otherwise, I was thinking that jurisdictional issue has to be decided first.
Yes, sir. Then the resolution professional may exercise the power vested under 99(4) for the purpose of examining the application for insolvency resolution and to seek information on matter relevant to the application in order to facilitate the submissions of the report recommending the acceptance or rejections of that.
So it is still pending.
Yes, your lordship. It is not completed, your lord.
Whatever resolution professional says, that will become redundant if it is decided that Guwahati NCLT does not have jurisdiction. We were inclined to pass that order, set it aside, decide the jurisdictional issue first. So the matter is pending.
Matter is pending.
Matter is pending. And it is coming up on 18th, your lords.
I don't think you should press this.
Lordship,
I don't think you should press this. Otherwise, we go. We were inclined in the first instance, but we were not aware of this Dilip B. Jivrajka. And they have not rejected your application.
Yes.
But Lordship,
Not
no order has been passed on my application.
All right, they have deferred it. In the meantime, a resolution professional has been appointed.
No, Lordship, may please to see page 16. What is the order, Lord? Argument was heard on miscellaneous application, Lord.
Hmm.
Page 16. Order dated
Yes.
6th of October.
Hmm.
1. Both sides counsel are present. Argument heard on IA number so and so. Learned counsel for the respondent 6 time to file counter petition on the main CP. Learned
That's
counsel for the
exactly-
petitioner submit that the IPR may be.
They have not rejected your contention that you are not the personal guarantor. It will be decided
is
in the
still pending,
meantime.
sir.
They say, you see this, have you given a copy of that judgment to him? Or you have read it
Yes,
out
yes,
here? Would
Your
have
Lordship,
heard?
I have. Yes, I have.
Get the issue decided there and then question it. No, we are not entertaining this now. UK, you have an option. You have an order of dismissal, or you withdraw this petition to come before this court again after the after the main issue, jurisdictional issue is decided.
Lordship, the second.
Either we reject it because of this judgment, or you, after some arguments, you would take down. Otherwise, also we'll say we must state the facts. This writ petition has been filed by a former director of Messrs. Balaji Exports Limited, bracket borrower / principal debtor, bracket close, a company based in Dibrugarh, Assam. The petitioner is a resident of Kolkata. Who seeks to challenge the order dated October 6, 2025, passed by the National Company Law Tribunal, Guwahati, in CP bracket IB number 1/GB/2025, under section 95 of the Insolvency and Bankruptcy Code 2016, bracket IBC. By the order impugned, a resolution professional has been appointed at the request of the respondent / Indian Bank, Union of India or Indian Bank?
Indian Bank. Your
Indian
Lordship.
Bank.
At the request of Indian Bank / financial creditor, respond number 2, without first adjudicating the petitioner's interlocutory application, which raised preliminary objections on the maintainability of section 95 proceedings and the territorial jurisdiction of NCLT Guwahati. It appears, next paragraph, it appears that credit facilities were availed by the borrower from the erstwhile Allahabad Bank, which later merged into Indian Bank in the year 2020. The petitioner at that time was a director and had provided personal guarantee for earlier loans. However, as claimed by the petitioner, for subsequent sanctions by the bank in the year 2020 and 21, which was after major restructuring of the loan, the petitioner explicitly refused to execute a fresh personal guarantee. The contention of the petitioner is that despite this, the bank disbursed the loans to the principal borrower, later classified the account as non-performing assets, and sought to recover approximately rupees 4.75 crores through SARFAESI proceedings against the borrower's secured interests. A separate recovery proceeding under the Recovery of Debts and Bankruptcy Act 1993 before the Debt Recovery Tribunal, Guwahati, was initiated, arraigning the petitioner as a guarantor, which is pending consideration before the court, correct?
Yes, sir.
The Indian Bank has also initiated proceedings against the petitioner under Section 95 before the NCLT in his capacity as personal guarantor for the borrower's debts. Critically, no CIRP process under Section 7 of the IBC has been initiated against the principal borrower. The contention of Mr. Kyal, learned advocate for the petitioner, is that this proceeding under Section 95 of the IBC against him is in fact premature. There is no substance in this argument, as the whole architecture of IBC permits parallel proceedings against the principal guarantor independently of the principal borrower. However, the liability of the petitioner would be created only if it is found that he is the personal guarantor. He has offered his personal guarantee for the loan, which the petitioner has questioned. This was his precise contention in the IA, which he filed before the NCLT Guwahati. It appears that the application has not been, it appears that such interlocutory application has been deferred for a future date. But in the meantime, a resolution professional has been appointed. Mr. Kyal, learned counsel for the petitioner, submits that it amounts to putting the cart before the horse, which is not permissible. The preliminary objection / jurisdictional question ought to have been decided first before going forward to appoint a resolution director, which will trigger many actions, leaving the petitioner in lurch, especially the moratorium. And other connected factors. The prayer of the learned counsel for the petitioner is that the order appointing the resolution professional of the NCLT Guwahati be quashed, and the NCLT Guwahati and the NCLT Guwahati be directed to decide the jurisdictional question first. Opposing such prayer, Mr. M. Sharma, learned counsel for respondent number 2, has drawn the attention of this court to the judgment of the Supreme Court in Dilip B. Jivrajka versus Union of India and others, 2024, 5 SCC 435. The conclusions formulated in the judgment explicitly declares that at the stage of Section 95 of 95 of IBC, there is no judicial adjudication. Semicolon, rather, the appointment of resolution professional only serves the purpose or collating all facts relevant to the examination for the commencement of insolvency resolution process. The report to be submitted to the adjudicated authority is only recommendatory in nature on whether to accept or reject such application. The conclusion of the court, of the Supreme Court, in the aforementioned case is being extracted here for ready reference. To stop at this stage, Mr. Kyal, learned advocate for the petitioner, realizing that the objection, that the hearing on the realizing that the hearing on the objection, hearing on the maintainability / jurisdictional objection has been deferred to a later date, seeks permission to withdraw this application in order to approach this court again, should such necessity arise. Allowing such prayer, we permit Mr. Kyal to withdraw this petition with the liberty as aforesaid, and with a request to the NCLT to decide the jurisdictional issue at the earliest.
Much of.
Dismissed if withdrawn with the aforementioned document. I think this serves the purpose both ways.
Your Lordship, one small correction, sir. Your Lordship, in one place, resolution director has been mentioned in place of resolution professor.
Sorry, director named professional.
Much of.
For admission, item 31.
Service is not.
May I please, Your Lord? Against the impugned shifting of the GP office, Your Lordship.
Just a minute, 1 second. Yeah, 31 minutes. Yes.
Your Lordship, the Rajnagar GP office is functioning from Manipur, which is a centrally located and the most convenient place since its inception, Your Lordship. And upon and from 30/12/22, it is functioning from the vacant premises of
Who
Tayabia,
appears for the respondents?
Your Lordship.
I'm appearing, Your Lordship.
You appear for whom?
Panchayat,
No, Panchayat.
PNRD.
Who appears for the secretary?
Yes, Your Lordship.
You appear, what is his name?
K. Kumar, Your Lordship.
Now, why don't you decide the application? We will not interfere in this.
Yes.
matter. You have still retained that Manipur as a place. The shifting process has begun. But before that, I think you'd be well advised to decide their representation.
Yes. Otherwise, also, Your Lordship, the shifting has already been completed.
Or if I'm saying something else,
Yes, yes.
he says in his petition that
My instruction
Yes,
is
yes, yes,
still
yes.
functioning.
can you allow the court?
Sorry,
Can you allow the court to speak?
sorry. Yeah.
Today we can't overpower your voice because today I have some problem.
Sorry.
He says that Manipur still remains the headquarters. You have only begun the process of shifting. Why don't you hear them? What you do is your domain.
Yes, sir. Absolutely.
See, why we are asking you to do this? Because the place which was this, where you're taking it to a place which was only recently, attached to that panchayat jurisdiction after delimitation. So you have to consider the facility of majority of the people And there was no question raised with respect to the location. You're changing it of your own. Now, if there is a government proposal to build office at all, I mean, build a new Panchayat Bhavan at all places, all right, then we don't question it. But here, for no apparent good reason, why do you shift?
Your Lordship,
Tell them
Yeah.
that this is what we have received, this is our instruction.
yes, it will be sir.
We are not passing any mandamus, we are not issuing any
Yes,
directions,
yes.
nothing.
Yes.
You consider their application, let them know.
Yeah.
This PIL, we have heard Mr. Ranjan Majumdar, learned advocate for the petitioner, and Mr. K. Kumar, additional advocate general, representing the Department of what is that department? Department of Panchayat and Rural Development. State of Bihar, it is called Panchayati Raj. State of Panchayat and Rural Development Department. This PIL challenges the administrative decision to shift the headquarters of Rajnagar Gaon Panchayat from its long-standing and convenient location at Manikpur village to perhaps a temporary setup at Sri Kona Gaon Panchayat office, approximately 5 kilometers away. Next part. The petitioners are the local residents and social workers from Manipur who have argued that the shift ordered by the District Commissioner of Tachar on October 9, 2025 only serves vested interest. Only serves vested interests of a few newly elected Panchayat members from Sri Kona, which was only recently added to the Panchayat via 2025 delimitation. Stop. There is no element of public welfare in such administrative decision of shifting the headquarters. It has further been contended that the current office at Manipur is housed in a vacant school building since 2022. It has a central location with essential amenities like primary health center, veterinary subcenter, and schools. It is also otherwise highly accessible for the economically disadvantaged villagers. Several complaints, next paragraph, several complaints, representations have been filed before the authorities against the decision to shift. But none of those representations have been adverted to or have been disposed of. It is also contended that the process of shifting has begun, but the office is still.
Your Lordship, as per my instruction, that is completed. And out of 10 ward members of the Panchayat, 8 ward members have filed representation asking for.
It is Ajay. Kalika? But the office is still continuing from Manipur. As opposed to the aforementioned contention of the petitioner, Mr. Kumar, learned additional advocate general, has submitted that the shifting is now complete. Shifting is now complete. First up, the shifting was approved by 8 out of 10 ward members. Nonetheless, we are of the view that the representations preferred by the petitioners before the authorities ought to be looked at even as a post-decisional hearing, so as to satisfy them that it was out of necessity and in public interest, such shifting was ordered, such administrative decision was taken. We therefore, without interfering with the decision of shifting the headquarters of the concerned Gram Panchayat, direct the authorities to dispose of the representation pending and let the petitioners know about the outcome of such
Your Lordship,
within a period of 6 weeks.
yes, Your Lordship, it was not approved by 8 members. Representation was filed by 8 members requesting for.
It has the approval and sanction of 8. It has the approval. It has the acceptance and approval of 8 of the 10 board.
Representation was filed before the authority by 8 members seeking shifting of the office.
Well, that's what I'm saying. That's what I'm saying. That's in your.
Your Lordship,
Obliged.
some protection, your Lordship, even status. quo,
Nothing,
your
nothing. We have not interfered.
Obliged.
Lordship.
Item 32 and 33.
KG.
Your Lordship, the writ appeal, the fate of the writ appeal depends on the outcome of the item number 33. That is a writ petition that we are challenging the particular act, that the clause 17 of the Assam Public Distribution of the article or order 1982. So it is yet to be admitted, Your Lordship, as because the petitioner has, his license has been cancelled based on the conviction, and that particular act of clause 17 says so, and it does not provide any opportunity to the other side to be heard.
Okay.
What is the 33? 33.
Yes, sir.
Yes, what do you have to say about that?
My Lord,
That's constitutionally not acceptable.
my Lord, there are 2 provisions. Provision, my Lord.
We are only seeking some reading down of section 17. of the-
17, my Lord. 17 has
You
said,
give
my
them,
Lord.
at least there can be no provision which does not permit any person whose rights are being taken away to be heard.
Right.
That's the only question. It has been decided in so many cases. If you don't change it, we will read it down. You have to file your response to the petition. Otherwise, prima facie, we are inclined to read it down.
Section 17. 15 said, my Lord, that inquiry should be conducted, and 17 said it's conviction, my Lord, then no.
So conviction, suppose conviction is under section 324 or whichever. Conviction is one thing. You must hear him.
My Lord, Tulsi Ram case, my Lord.
Maybe, I mean, his conviction is on the basis of application of section 149. He is just a member of the mob. Offense is 323, 324. Should his right to livelihood be disturbed? That is the whole question. And you can't leave him high and dry. You just, for anything, even for statutory license, you can say that conviction, a convicted person need not be retained as a licensee. But before taking away that license, you must hear him. You say nothing is required. Once conviction, whether conviction is stayed, sentence is, see, unless conviction is stayed, your section 17 operates. In his case, sentence has been suspended. But then you have to look at it. No, he is a licensee. He has to look after his family. That is the only source of livelihood. And you just can't take it away without affording him even the basic, elements to defend his rights to be heard. File your affidavit and we are going to read it down. We are making it very clear. Either you do it or we do it.
My Lord, we'll file a affidavit, my Lord. And my Lord, main order of the deputy commissioner, there is also, my Lord, appellate provision is there, my Lord, section 29. In the main order, my Lord.
Appellate provision is there.
Appellate provision is there.
What is there?
Section 20, clause 29, my lord. Against the deputy commissioner, my lord, he can file the.
No, no,
affidavit.
section 29 says what?
My lord, 29 said, my lord, there is an appellate provision, my lord, if the any cancellation, my lord. Person aggrieved by the order may be the officer
I've
under
seen
the
this
order may.
law, this
This
kind
order
of
passed by the
statute is
deputy
always.
commissioner, my lord. Order made by the deputy commissioner appealed to the commission. 29.
नहीं भी होगा तो ठीक। Island affidavit.
My lord.
Wait. Both the matters have been taken up together. We have heard Mr.
Yes, Sabri Ahmed.
Mr. S. Ahmad, learned advocate for the appellant, and Mr. Saikia, learned government advocate. Sam. The appellant in WA number 248 of 2025 has challenged the impugned judgment passed by a learned single judge in WPC number 3705 2025, whereby he has refused to interfere with the cancellation of the license of the petitioner to run his ETS shop on account of his having been convicted in a case. The learned counsel for the appellant submits that though the cancellation of his license was because of his conviction in a minor offense case, but the sentence imposed against him had been suspended. It has further been contended that the learned single judge did not take into account that whether statutorily or otherwise, before taking away his license, he ought to have been heard. The contentions raised on behalf of the appellant were opposed by the state by only referring to clause 17 of the Assam Public Distribution of Articles Order 1982, made in exercise of the powers conferred under Section 3 of the Essential Commodities Act 1955. Section 17 of the Order of 1982 clearly says that when a license has been that when a licensee has been convicted by a court of law, or there has been a contravention of any order made under Section 3 of the Essential Commodities Act, bracket Central Act 10 of 1955, the licensing authority shall, by order in writing, cancel his license without giving the licensee any opportunity of stating his case. The appellant realizing that he has lost before the learned single judge only because of the operation of clause 17 of the Assam Public Distribution of Articles Order 1982. He has now sought to challenge the constitutionality of clause 17 on the ground of it being highly unreasonable, arbitrary, and violative of Articles 14 and 19 of the Constitution, 19(1)(g) of the Constitution. By way of another writ petition, namely WP number Swens. The issue for consideration would be whether automatic cancellation of license on conviction without hearing the licensee would violate the principles of natural justice, and whether cancellation based on any conviction, even unrelated to public distribution system or essential commodities offense, is disproportionate. Thus, what has to be decided in the writ petition is whether Section 17 withstands the scrutiny under Article 14, 19, 1G, and 21 of the Constitution. Let response affidavit on behalf of the state be filed in WPC number 6028 of 2025. Let this matter come up for consideration. Let both the appeals come up for consideration. February. Now we have made it very clear. We will read it down. We will say that you must give him an opportunity to hear till the time the rules are changed. We will not now say with respect to the offense should only be with respect to EC Act, because other states also. I've had a check long time back on these aspects of the matter while serving in different jurisdiction. Because of our objections, the entire control order was rewritten. And now it gives every opportunity to a licensee to appeal, and then no decision could be taken of cancellation of license without giving him good opportunity. Many times in criminal cases, when a person was made accused, he would run away. The shop used to be closed. So taking that into consideration, the licensing authority would cancel the license. But we realized that the police unnecessarily was troubling them. So they had to run away till the time their anticipatory bail applications are decided. This caused a lot of trouble, not only for the licensees, but the targeted, citizenry also, beneficiary also. Normally, knee-jerk action would be taken by the authorities, attaching the beneficiaries to another PTS, but that was not solving the issue. And therefore, the entire, the control order, the penal provisions, they were restructured. So we are going to say this.
Right. 15 is there.
File your response. Take the example of other states. UP, state of Bihar, Maharashtra. Otherwise, we find it to be very, very unconscionable. Can you say in 21st century, 22nd century that without hearing, we will do anything? Can it be said? We have indicated our mind. We will not wait for you. We will, if we will not scrap this, we will read it down.
18 February. Yeah.
Take care.
18 February. 18 February. Item 35 and 36.
Yes.
Lordship, here, on behalf of the Finance and Taxation, I was supposed to file an
On behalf of?
Finance and Taxation Department,
Yes.
Lordship. Due to bereavement yesterday, Lordship, I couldn't
Mention it in the morning.
in the morning, Lordship, I got caught up in the traffic jam at Panbazar, Lordship. That I couldn't reach in time, Lordship.
Who appears for the appellant?
Lordship,
Chaudhary. That
Lord,
appears that
there
you-
was,
it
they,
appears that you had only argued this.
yes, they made a request in the.
That's all right. Request is all right, but let me understand the issue. Now, they have permitted the exemptions with respect to bottles.
Yes,
They have refused exemptions only on mineral water, on packaged water. There's a central, there's a judgment which says that packaged water is no manufacture. You'll have to argue this. You'll have to
yes,
satisfy
yes.
this. Because whatever may be the reasoning given, water, if it is purified and packed, there is no
Whether it will amount to manufacture.
manufacture.
in
And that
order to
will
get
go-
the benefit of the industrial
Exemption.
policy resolution.
And exemptions, they have to be read very strictly. Therefore, they say when you manufacture a plastic bottle, PET bottle or
PET bottle.
that's a manufacturing process because raw material is used. There is
Even that has been denied.
no, that perhaps has been allowed to you.
Not my
No,
lord.
yes, sir.
Anyway, my lord, today, to be honest, since they have prayed for time, I am also not fully prepared. And my lord, lordship will have it any date convenient to lordship.
See, it's a new scheme of 2005. 2005 or 15.
But my lord, our entitlement, if it is to be denied, then the industry department will have to first withdraw it. That is not done, my lord.
No. They have said, I mean, the learned
No,
sage
Lord.
just says that all that in the past was bad.
No, my lord. If your
We
lordship
have
said
done that. You can argue that.
that state of Bihar case, where my lord, then once industrial policy resolution is there, because the cabinet takes the call. Therefore, an individual department cannot take a contrary stand. That the Bihar case, Suprabhat Steel's case, where it says,
I have no idea.
yes, Suprabhat Steel versus State of Bihar. That's a case on exemption, my lord, where the Honorable Supreme Court said that once a cabinet takes a call with regard to granting of exemption, finance department cannot take a contrary stand. To that extent, my lord, finance department's approval has been construed to be a ministerial act, only to give yes to the policy resolution. Now that stands.
That approach we will see it on next date. But you tell us whether packaged water is it is by virtue of a manufacturing process. I don't think so.
And that's a debatable issue, my lord. I'll address your losses on that fight.
We say as jointly prayed for?
Yes.
As jointly prayed for, list these matters on sometimes in March.
I love that interim order has to be continued, my lord.
Don't ask anything from us. Whenever it is a statutory provision or something, we say no coercive step. What does it?
Yes.
So we have not interfered.
Whatever is there, my lord.
It remains.
Yes.
Whenever there is an occasion to pass an interim order, I am very suspicious. I hear it just now. Because these are, these relate to fiscal issues of the government. Very
Correct,
difficult,
correct.
very
No-
difficult
normally-
to turn the clocks back. Then other principles start, they get triggered that you can't do it. Once benefit has been given, returning the amount which you accept from the state is very difficult.
Anyway, difficult.
So we don't say anything. So interim order.
Whatever is there is there.
Lines batch. Item 38.
नहीं but admit नहीं हो सकता ना ये national consumer portal नहीं go to this. I think this is beyond jurisdiction. You can't you can't challenge a judgment of the National Consumer Commission before High Court. It has to go to Supreme Court unless I'm not very sure.
My lord,
There is an order, my lord. Order, my lord.
Whatever is the order, if we don't have the jurisdiction, order होने से क्या होगा? Even if it has been admitted, we'll say it is wrongly admitted. There is no difficulty in admitting our fault. I don't think the jurisdiction lies here. देखें, where is the act?
my lord, as per the act, my lord, if you go and then it is Supreme Court. No?
So therefore, why was it admitted? You should have raised that objection, no? You should have raised that objection.
But my lord, there was a my lord, order from the Honorable Supreme Court, my lord, in the year 2023 regarding filing of my lord.
No, how can there be an order
my
against
lord,
this statute? I remember every such petition to be filed in Supreme Court. Let's see. Find out and tell us. I think it has to be. You'll have to withdraw. But take them. Let's see what.
Supreme Court में दिल्ली हाई कोर्ट ऑर्डर थी
दिल्ली हाई कोर्ट में এই order to be Supreme Court
तो नजारा के करेছে नजारा करेছে
Jurisdiction. Which provision?
appeal to national hearing.
24, okay. Review it by the state for the review. National Commission कहाँ है?
इसमें मतलब section 50 में लो the appeal against order of National Commission is page 67, Lord.
Page 67.
Page
Section 67.
section 67. Yes, sir.
Supreme Court.
Supreme Court.
लिखिए. Though this petition has been admitted.
Malad, I will let it be on the on the next date. I will produce the judgment passed by the Honorable Supreme Court regarding filing of these cases before the High Court. And after that, my lord, not only my case, my lord, we have they have given directed to file it before jurisdictional High Court. Before filing this court, before this Honorable Court, we have approached the Honorable Delhi High Court.
That is different.
That batch of my lord, the petitions were filed before, my lord. And after my lord, all those jurisdictions were remanded back to file it before.
What are you advancing? That time there was a direction to file it before this court because you had not gone before the National Commission. You were challenging the State Commission's order, or perhaps the other side was challenging it. We don't know. Give us that judgment. We will not entertain this unless there is a Supreme Court judgment which says they entertain it.
Lord, I'll put it on the next date.
Tomorrow.
Tomorrow.
This is wrong. Without the decision, this has wrongly been admitted. Which judgment? In this case, there is a judgment of Supreme.
Not in this case, but it's a.
Where is that?
Malad, I'll produce. Malad, let it be on the.
Can any judgment be against the statute?
No. Not on. It is not that, my lord. Not only me, my lord. Law. A batch of rich person. They
First time I'm hearing that a National Consumer Commission's judgment is being challenged in High Court. At least this has been my experience. I have not seen that. And how can it be when Section 67 is so specific?
My lord.
Any order of Supreme Court would be with respect to that specific case. Anyway, you should tomorrow. Tomorrow. Let this sub pass over, let this matter come up for consideration.
Item 39.
May I please, Your Lordship, I am extremely sorry, Your Lordship. I missed the matter in the cause list, Your Lordship. Not prepare, Your Lordship.
Tomorrow?
Tomorrow, Your Lordship. Sorry.
Tomorrow बहुत cases नहीं लगाना जो आज का पास ओवर हो रहा है Day after tomorrow, maybe after vacation. At the request of, this is antedating the promotion. Mr. Chaudhary, this court has some hesitation.
No, my lord, the learned Singh.
So far as, see, the act says that any person who acquires,
Yes.
and if there is a vacancy, he must be promoted. Nothing was done. Vacancy is of the year 2014. Right. By virtue of the judgment, they were supposed to explore what is the vacancy position and how many persons have.
Within a period of 6 months.
Within a period of 6 months, they do it after 3 years.
No, my lord, question is the first judgment was a declaratory law. The learned single judge has constituted to be a judgment in personam. That is why these consequences ensue. Only thing is, my lord, benefits are given to us also.
Difficulties with respect to that judgment also. Can the courts acting under Article 226 decide that now when there is no specific time limit for giving promotion, can it decide that do it from 6 months, do it antedated to that month? It is, the law is that.
No, we are only asking for entry to the extent of 6 months only, as the benefit was given to the others.
6 months, why 8 months, why 12 months?
Why not from the very beginning? No.
What is the rationale? What is the watershed logic?
No, because, my lord, the honorable court.
Anyway, he has to, what?
No, on the last occasion, Lordship asked my learned friend to have the instruction whether this benefit would be given to us or not.
Why not?
Yes.
If either we cancel that,
Ah.
which nobody has come to challenge it. So therefore, no distinction has to be made.
No, in the
That-
facts,
but I'm,
in the facts of this case,
are-
we are making this
we-
prayer, my lord.
we are not in favor of that. That was in excess of the remit which the single judge had. Unfortunately or fortunately, the state did not challenge that. So we will not disturb it otherwise.
That's all. Only to that extent, my lord.
But technically speaking, legally speaking, that order is suspect. As prayed for on behalf of the respondent and agreed to by the counsel for the appellant. Re-notified March.
Oblige you.
6 March. Item 40.
Amaju?
These rules, these departmental rules, Mr. Chaudhary, these departmental rules need to be, updated.
Yes.
Open-ended. Whoever acquires, what does it mean? Subject to vacancy, what does it again mean?
Some vagueness are there. my lord.
All right. Yes, Mr. Chaudhary. Junior.
In fact, my lord, in the other parts of the country or under the central rules, what we find is, in case of degree holder, qualifying service is less. And in case of diploma holder,
Right. That is the,
qualifying service is 8 years and 5 years normally.
so it happens. And then with the vacancy position, they come out with the advertisement. They permit all these people to appear.
The mandate of the rule is, my
And
lord, the
special-
moment the vacancy occurs, right accrues, provided I obtain the degree.
There is another logic to it. It says that if he becomes a junior engineer or maybe assistant engineer, that is fresh upward.
No, it will be treated as a direct recruitment.
But fresh
That is
upward
a-
means direct recruit. And therefore, the necessity of the urgency in making them assistant engineers on the vacancy. And because they lose out on the earlier tenure, that will not be counted.
Right.
So that could be one reason, but it is not working well. Anyway, yes, Mr. Chaudhary.
No, I'm for the respondent number 1.3, madam.
Lordship. Lordship, here, Lordship, you have preferred this appeal, Lordship, against the order dated which in page 24, Lordship.
What has happened?
Page 24, my lord, may directly come to page,
No, before taking us to various paragraphs, tell us what has happened.
my lord, may directly come to
आपकी
page.
तकलीफ क्या है ये बताइए.
Lordship,
Where has the justice?
Lordship.
Yes.
The some decisions taken by the cabinet, Lordship, regarding regulation of a particular 2-3 employees, Lordship. And on the basis of that cabinet regulation, Honorable Single Bench directed the authority to take a cabinet decision in respect of the petitioner's case, Lord. In paragraph 24, 38 and 39, Lordship.
Paragraph?
Paragraph, page 38, my lord, may kindly page 38, paragraph 24, Lord.
Paragraph 24.
24 or not, Lordship.
Yes.
Thus, drawing premises from the discourse made herein above, and also having regard to the facts and circumstances of the record, this court is of the considered opinion that petitioners have succeeded in establishing a case for interference of this court, being similarly situated with the said 8 numbers of contextual lecturers of Haflong Government College and 3 numbers of contextual lecturers of Depot Government College, whose service was regularized on the basis of the cabinet decision by notification dated so and so, Lordship.
1 second.
Lordship.
भेज सकते हो. No, no, not paid. They, but they did not come in the zone of concern. Thank you. Judgment of the- This Department of Education has the, where is that notification of 2005 submitting the Department of Education under the administrative control of NC Hills Autonomous Transit? But how did you take cabinet decisions with respect to others? I mean, we are just asking.
Lordship, Lordship. Lordship, cabinet on its own wisdom, they have taken decision at the relevant point of time. Today, I cannot, Lordship, go,
The court, today you cannot, but the court, the single judge judgment is only based on that.
Lordship,
You cannot, so you cannot. Negative equality, the court says that no, you're wrong.
Lordship.
Department of Education has been transferred. It's a transferred subject.
No, Lordship, higher education is not a transport subject. Lordship.
Where is your plea?
Up to school education. Lordship.
Where is your plea?
We have in our affidavit, Lordship. In our affidavit, we have clearly stated, Lordship. In our affidavit, Lordship. And even, Lordship, they are also initially they are engaged at PF appointed,
Those
Lordship.
facts we know.
Lordship,
We have spent 5-10 minutes, so we know.
Lordship.
They were working on contract. Their contract was terminated. Thereafter, they were rehired. They
Lordship.
appeared
Lordship.
before the body which was there for regularization, for regular appointment
Lordship.
under DSM service rules. They passed also,
Lordship.
but because they fell beyond the zone of
Zone of
consideration,
consideration.
they
Lordship.
were again terminated. They were rehired.
They are terminated on the basis of the Honorable High Court Division Bench
You
judgment.
tell us, you representing the government, tell us what is the vacancy position, when are you going to advertise?
Lordship.
Mandamus could not have been issued to the
Lordship.
cabinet. Cabinet
Lordship.
mandamus nahi issue.
Lordship, even Lordship, that advertisement was.
Mr. Gogoi, you have to raise proper question, legal question in this appeal. The first point should be that no mandamus can be issued against the cabinet.
Lordship, that part we have taken the ground, Lordship. In the ground we have taken, Lordship. Lordship, page 16, Lordship. In specific, our ground is that ground, Lordship.
Look at the last paragraph of the judgment, Mr. Chaudhary.
My lord, only it has been directed
This
to
is
the
what,
place.
this is what is making us, look at it from different perspective.
My
There
lord,
is- just a minute.
mandamus,
Just
sorry.
here. The respondent number 2, by a mandamus of this court, is directed to place the matter of the present petitioners before the state cabinet for its kind consideration for regularization of the- as done in the case. Place it before the cabinet.
Place it before the cabinet. My lord, it's not the mandamus has not been issued to the
It's to the
cabinet.
Number two, you're right. You're right. This is permissible. This can be done. Place it before the cabinet for taking a decision. So let the cabinet take a decision. There is no mandamus to the cabinet. That is for the kind consideration of the cabinet. Take a call.
But lordship,
Take a call. Let it come before the cabinet. We'll see.
otherwise lordship, our main,
Let the cabinet reject it. He will come again. We will see. Take instructions. I think we will write against your council that you are handpicking, cherry picking people. So far as we are concerned,
lordship,
we understand the law
lordship,
in its perspective.
lordship,
We are concerned with Assam service regulation rules,
lordship,
education service rules.
lordship,
Under it, appointments have to be made. Now the same rule will apply. The Hill Council also will apply the same rules if they have not made any rules. And if the higher education has not been transferred, they can't do anything. They have to keep on hiring.
lordship.
So therefore, they have to seek permission from the state, from the Guwahati government. So in either case, the cabinet has to take a call.
Otherwise lordship,
Afraid you let the cabinet say that
lordship,
the lecturers in other departments were
cabinet
better.
decision is a formality lordship, the all the memorandum is
Take
issued by the.
instructions and then get back to us. We are not concerned. Then we will dismiss your appeal on this ground that you are cherry picking people.
That part lordship may do it, otherwise
No,
lordship,
it escaped my attention that the mandamus was to the respond number two and not to, if it were of the cabinet, I would have stated it straight away. You can't issue a mandamus to a cabinet. That's
true, my lord.
inclusive board. That's a body which is to take a call.
And my lord, it is one point here I must point out, my lord, the council has taken a stand in their affidavit that they have got the power to appoint. Although, my lord,
Our respond number three's affidavit that it has been transferred.
then lordship
Yes,
may
he
direct the
said-
council, lordship, we have no objection, direct the council, lordship.
council says, my lord,
If lordship, the council can appoint them, lordship, pay them,
Mr.
lordship.
Gogoi, that is
Lost.
not the way you respond to a senior advocate's
Lost.
submission.
I'm extremely sorry, lordship. I'm
You
extremely sorry.
don't respond like this. It's like saying that you're asking me. We take it from court. I mean, that's not the way. He's making a submission, just respond to it
Lost.
logically, legally. This is no duel between two parties.
Lost.
Now it is your affidavit. You're saying take it from the council level. That's not-
Lordship,
that's
our
insulting.
specific,
That's disrespectful to a council.
lordship, our specific stand is that, lordship, it is not a transport.
That's something different. We are on a decorum of the court.
Lordship,
You're a young counsel, don't respond like this.
I'm
Say
still,
that it is not possible, even if the lawyer has done, he would not be under, he has no authority to admit and he can't admit something which is not there.
lordship,
These are the probable answers.
I'm still sorry, lordship. Sorry.
This is, no offense to us.
No, lordship,
But then young counsel should follow this principle of court decorum even more. Right?
lordship.
Take instructions. Why have you appointed others? In what circumstance have you appointed others?
Lordship.
Why will you not do to them? And it is only what is the direction? Direction is to place it before the cabinet. Do it before the cabinet. Let cabinet decide. We are not saying anything.
Right.
Reject the proposal. He will get another opportunity to come before us. Then we question you or don't question you. We say that you don't have a right, whatever.
Right.
Take instructions whether you will place it before the cabinet or press this appeal. Otherwise, we have no ground to say that you're doing it for others, not for them, even though they have put in as many number of years in service and there is a vacancy.
Vacancy, that particular vacancy.
Mr. Gogoi, have you understood?
I understand.
Why are you arguing? Take instructions.
Lordship, lordship.
Take instructions and then get back to it. Otherwise, we are finding it difficult. How do we tell Mr. Chaudhary that, well, you have no case when you have already appointed people?
That part is there. I am not saying that Lordship,
So
something,
therefore, the cabinet-
something was, today also I said that something was done. Lordship.
therefore you seek instructions from Hill Council whether, I mean, whether to pursue this appeal. We will say, if you say that no cabinet will take a decision, you don't press this appeal, take a decision. Acha, his response number 2 is
Lordship, I am representing Assam, Lordship.
your Commissioner Secretary, Government of Assam.
Lordship.
No, before which cabinet they have said? Assam government.
Assam government, Lordship.
Place it before the cabinet. Place it before the cabinet. We'll then dismiss it. Had it been Hill Council, I will. Assam cabinet, yes. See, the better option for you is place it before the state cabinet, let the state cabinet reject.
Lordship.
Therefore, we say take instruction.
It's after vacation, Lordship.
Let this matter come up for consideration on February,
Your Lordship, please.
first week, second week of April. We'll hear you on the other day. You be here, doesn't matter. We don't want any instruction from you. We don't want any.
11 February. 11.
We are not disqualifying you from appearing, but we will not pass any order. We don't require you. You keep track of this case. You come on that day, we'll tell you. But to our mind, you are nobody here. We don't require your presence. If you're there, we don't even reject it. More the merrier for us.
Item 41.
May it please your Lordship. Lordship, an affidavit on behalf of the District Commissioner Kamrup. Lordship, it's ready. Lordship will receive it within the course of the day. We can file it within a day, my lord. Regarding the action taken, Lordship, after formation of the committee.
What's your name?
Lordship P. Barua.
Must be Barua. Then it state submits that the affidavit required to be filed in this case has been made ready and shall be filed during the course of the day with a copy of such affidavit served upon the counsel for the petitioner in advance. Let that be done positively. Let this case come up for consideration. January 3rd, last week.
Deeply obliged.
29 January. Supplementary list, item 43.
Yes.
My lord, in 2019, the post of the principal was advertised, my lord.
Just
Then the
2019 post of the principal
of this
Higher
particular
secondary
school, higher secondary school was advertised. Then, my lord, the school selection committee recommended my name.
you are Sajal Kumar Das.
Yes. And then, my lord, it was forwarded to the state selection board. Now, state selection board on 27/7/2001 came up with a communication to the director of higher secondary education that since there is some doubt about my BA degree,
yes,
therefore, my lord, the name of respondent number 6 was approved. So I laid a challenge against that 27/7/21 order in WPC number 3558 of 2021. There, my lord,
but before that,
yes,
before that, there was a writ petition.
there was a writ petition, my
Let
lord,
us- let
that
us
is,
have- Let us have it in sequence.
yes,
First of all,
7890 of 19.
you were appointed, you were directed to be appointed the principal.
Yes.
Then respondent number 6 here.
No, my lord, no, my lord. At that stage, when 7980 of 19 was filed, nobody was appointed. Nobody was appointed, but he came to know that district level selection committee has recommended my name. Therefore, he filed the writ petition. And that was disposed of with the direction that it should be, his representation should be considered in accordance with law. Anyway, matters stood there, my lord, it need not proceed any further. Eventually, on 27/7/21, on the ground that my BEd, the institute from which I obtained my BEd degree may not be legitimate, therefore, respondent number 6 name was approved. And he was appointed. Then, my lord, I laid a challenge before the learned single judge.
3558.
3558. There, my lord, if your lordship would kindly come to page 29.
Page 29, yes.
Yes. Para 8. The panel list prepared by school selection committee was accordingly placed before the state selection board as required under Rule 13(3). The state selection board, as provided under Rule 13(4), prepared the select list which was placed before the government for its approval as required under Rule 13(5). Additional Secretary to the Government of Assam Secondary Education Department in its communication dated 27/7/21 addressed to the director while conferring approval of the government under Rule 13(5) arrive at its conclusion that respondent number 6 may be appointed as regular principal. By the said communication, it was provided that petitioner had obtained his BEd degree from Borpeta BT College, which is a private college in the year 1997, and as the head college received NCT recognition only on 14/9/2005, therefore, as per provisions of the NCT Act, BEd degree obtained by the petitioner in the year 1997 would be an invalid degree. And this was regarding me, my lord. Now, para 11 is very important, my lord, because it will have a relevance in this case. Sri So-and-so learned senior counsel appearing for respondent number 6 on the other end contents that the decision of the while granting approval under 13(5) is a right decision, and respondent number 6 upon being appointed at in the meantime assumed the charge as principal of so-and-so. Now, please kindly take note of this argument of respondent number 6 that there is nothing wrong in this election, my lord. Subsequently, my lord, grapes have become sour. Now, this honorable court directed at page, my lord, 31. Para 14. Appropriate authority shall specifically call for the records from the Borpeta BT College as well as from NC2 to arrive at a factual satisfaction as to on which date college made its application for recognition before the NCT. Depending upon the materials that may be available, appropriate order may be passed. If the order to be passed by the approving authority in the government is in favor of the petitioner for the purpose of other consequential action that would be required to be taken, both the writ petitioner and respondent number 6 would be given an opportunity of hearing to put across their
That's right,
respective.
you are appointed.
Yes, I am appointed. Now, my appointment is challenged in my lord WPC number 2442 of 2023. Now, my lord, in that writ petition, not only my selection was, my validity of my BEd degree was put to challenge, also the statement of marks, my lord, were put to challenge. But that challenge was given up. I am on that point. That's why it was my case, my lord, that it is barred by constructive res judicata. Because every time they are repeating this, my lord. Even there are subsequent to writ petitions also, the same plea was taken.
Nothing has been decided as such, no?
Yes. Not decided, my lord.
No, it has not been decided.
No, my lord. I am on the
No, end result is that.
No, my lord. I am not on res judicata. I am on constructive res judicata explanation 5 to section 11 CPC. If a point is taken, if it is, my lord, if it is not considered by the court, yes, one has
It will
to
be deemed to be rejected.
reject.
No, but here the different issue has come up.
No, not different, my lord. I'll show. Please come to me, lord.
For the private respondent.
Nobody has appeared. my
Let notice, we'll have to issue notice. Let notice be issued. Mr. Khatniyar, you accept notice for others?
Yes, ma'am. For number 1, 2, 3, 4. 1, 2, 3, and 4, madam.
Meanwhile, my lord, respondent number 6 has been divested of his financial power because of his irregularities. I placed that order, my lord.
He has not challenged it.
No, that is not even the subject. I just point of information, my lord.
It's- One second, one second.
4 easement.
What? 1, 2, 3, 4.
Selection committee is full or no?
School road.
Look here. Mr.
Normally we do not represent.
Mr. N.J. Khatania, learned advocate for the state. Learned, your standing counsel,
Education department.
Education Department accepts notice on behalf of response number 1 to 5. Let notice be issued to respond number 6 on steps being taken by the appellant within a period of 2 weeks.
Not to, well, will take within the next 2 days, Mila.
But then it shall go in February.
No, January. Because the man is retiring, Mila. He has got a lot of tenure, Mila.
Okay. Then January last.
Yes, 3rd week, Mila.
Returnable, both modes returnable. Yeah.
Mila, I may be permitted Dusty also. Or you may be permitted to serve copy upon the council who appeared, Mila.
No, no.
If they refuse, okay.
Dusty.
Dusty.
Councils keep on changing, no?
No, Mila, here in our
I
part.
would I as a lawyer never accepted notice in a matter where I was not engaged.
No, Mila, the practice
Every appearance before a court requires,
approval.
approval.
But that is a practice which we are not following, Mila. Because
No,
our
old high court.
clients are not that resourceful as in Delhi.
Telephone,
Uh-huh.
telephone, not Delhi. I'm talking of as less resourceful or equal we have. Without a telephonic instruction, suppose
Correct.
the client says that no, you did not argue on the last date, I'll have another one. Why should you appear?
Right.
And you should not raise any objection.
Correct.
So that this will pave way for another case to him. Then notice. That's the
Deep level.
19 January.
19. Deep level.
Item 44.
lawyers, Mr. Chaudhary, I fully sympathize with the community for the reason that they are the most vulnerable community. You know, the courts also show distrust. Party also shows distrust. That's a very unenviable position.
Correct.
Notwithstanding the huge money that they earn in practice. But this is the problem. They have to prove their bona fides everywhere.
Correct.
And that's a difficult task. I have done it for 22 years. That's a difficult task. Yes.
Deep level.
Item 44.
Your Honor, from today, the DRT is available and their matter was come up before the DRT today itself.
What happened?
She's there, but this matter was fixed today, so I thought let me appear before this lordship, because lordships had said to
Well-
come with an instructions. If your lordships would.
Now go before DRT, press it before DRT. Otherwise, technically speaking,
Right.
here the DRT would place it, you go before DRT, argue the case
Yes.
as well as you have argued here.
No, my lord, I'm only requesting that if your lordships do interfere, only to the extent.
we will
There
not-
is no urgency as such because
We will not interfere for the reason
Yes, ma'am.
that there is every possibility of the DRT ruling in your favor.
Right.
See, you have made all payments
Yes, my lord.
and you
To
argue,
the larger extent.
and you
yes.
argue that earlier default with respect to car and other things, that's different.
Yes,
That should
ma'am, that's not
you should
involved
not
in
hear
this.
this.
Yes, ma'am.
The moment bank permits you to deposit money, if we want, we can keep this pending or we dispose it off that the matter is pending before DRT. We can't keep it pending
No,
because
I don't think your lordship, I think your lordships can then give me a
considering
direction.
the fact that considering the fact that the DRT Guwahati is considering the fact that the same issue is pending before the DRT Guwahati today.
today.
Today is listed today, man. Item number 6.
Today,
Yes,
Mr. R.B. Fukan, learned advocate for the petitioner, does not press this petition in order to pursue his remedy before the tribunal.
I'll be extremely good.
Dismissed as withdrawn with the liberty of course.
Extremely good.
Otherwise, if DRT would have refused DRT, of course, we could have done that during vacation.
Yes.
Today it is listed. What do we do?
Extremely good.
Okay.